Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by livelaw. We bring to you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. A Delhi court today remanded NewsClick founder Prabir Purkayast and human resources head Amit Chakrabarti to police custody till 2nd November in the UAPA case registered following allegations of the portal receiving money for pro-China propaganda. As you know, they were arrested on 3rd October, were remanded to 7 days of police custody on 4th. Later, they were sent to judicial custody for 10 days, which was extended to 5 more days. Also, let me tell you, the duo has moved the Supreme Court, challenging dismissal of their petitions, challenging their police remand. The Kerala High Court today remarked that the state has the duty to support junior lawyers belonging to OBC category. The single bench of Justice Devan Ramchandran was hearing a plea moved against non-issuance of notification to claim annual grant of 12,000 rupees to the junior advocates belonging to OBC category under the OBC Advocate Grant Scheme for purchasing law books, gown and uniform. The counsel for the petitioner submitted before the court that once selected for the scheme, an advocate would receive an annual grant for 3 consecutive years. It was submitted that due to non-issuance of notification from the year 2022, the selected junior lawyers of 2021 were not getting the benefit of the scheme anymore. The counsel for the respondent submitted that the scheme was discontinued due to financial crisis. The court then stated that the scheme was for upliftment of junior lawyers belonging to OBC category and it was only an amount of 12,000 rupees a year. The matter has been posted to next week for further consideration. In another update, the Delhi High Court today refused to grant permission to an organization to hold a public meeting at the Ram Leela ground on 29th October. The petition was moved by Mission Save Constitution, an organization which claims to work for creating awareness among the masses, especially the depressed classes, about their constitutional rights. The proposed event was scheduled for 29th October. Called the All India Muslim Mahapanchayat, it sought to initiate a series of events for strengthening of all weaker sections, including Muslim and other minority communities like scheduled caste, scheduled tribe, other backward classes, and that voices of all the oppressed people would be raised in the meeting. The organization had challenged the Delhi police's decision to revoke the permission which was earlier granted to them. It was the police's stand that the proposed event was communal. Justice Subramaniam Prasad upheld the Delhi police's decision, observing that it could not be held to be arbitrary. The court also said that the period of end of Shraddh till Diwali is extremely auspicious for people belonging to the Hindu community, and that the posters of the organization show that the event could have communal and religious overtones. While disposing of the plea, the court, however, said that it is always open to the authorities after the festive season is over to consider afresh the organization's plea for permission to hold the event. In an important observation, the Chhattisgarh High Court observed that in the matrimonial house, the wife should not be treated as a hired chattel or a bonded labor to stay under the conditions imposed by the husband. The bench also opined if the husband expects the wife to stay at a place other than his company without any sufficient cause, and if the wife resists his demand, it will not amount to cruelty by the wife. In the present case, the couple got married in the year 2008. Husband had sought divorce on ground of cruelty, which had been allowed by the family court. It was the case of the husband that he wanted his wife to reside with him in his village, but the wife did not agree for the same. The wife who appealed against the decision of the family court contended that she was always willing to reside in the company of the husband, but he never wanted to keep her with him and wanted her to reside separately at the village. Taking into account the facts and circumstances of the case, and the evidence adduced by the parties, the court noted that from the very beginning, the husband did not accept the request of the wife to keep her with himself. The court concluded that none of the grounds had been satisfied individually or collectively to entitle the husband to claim divorce. Hence, the appeal was allowed and the impugned judgment passed by the family court was set aside. The Madras High Court has come to the aid of two Tamil women claiming compensation for the death of their husbands in Nigeria. The husbands of both petitioners had died in an accident while they were traveling in the company car in Nigeria in 2013. They had requested to arrange the insurance amount and also made representations in this regard and had approached the court seeking directions to the Ministry of Home Affairs and the Ministry of Overseas Indian Affairs. Both ministries had acknowledged the applications and forwarded them to the company and the Indian Embassy in Abuja for necessary action. Though the only remedy available to them was to pursue litigations against the company, the Madras High Court noted that there was a responsibility upon the ministries to take appropriate action through the embassies. So, Justice B. Pugalendi observed that the court was not in a position to issue any positive direction as Nigeria was not included in the compendium issued by the ministry for getting reliefs for Indian nationals who died abroad. However, considering that the petitioners were young, poor widows who could not pursue litigations in Nigeria, the court directed the center and the respective embassies to pursue representation with the company where the husbands were employed as per the compensation rules in Nigeria. In another update, the Kerala High Court has issued notice on a petition filed by a lawyer alleging manhandling by police officers earlier this month. The petitioner, who is also an acute heart patient and had undergone angioplasty, alleged that himself and his wife were molested and brutally manhandled by the police officers of Firoke police station on two occasions. Once on a public road where he had parked his car and was in the middle of some discussion with his client, when the two police officers approached them alleging that they were creating a riot on a public road and further brutally manhandled the petitioner and his wife. The second occasion was a few days later when the petitioner took his dog for a walk at around 12:15 a.m. in the night and was thrashed by the respondent sub-inspector with a lathi and hurled with verbal abuses. Two false FIRs had also been instituted against him. His wife had filed complaints before the city police commissioner and the station house officer of Firoke police station seeking immediate action against the police officers. Therefore, on apprehension of further such assault from them, the plea was filed seeking the issuance of a direction to the officials not to harass him further. Justice N. Nagaresh issued notice and passed an interim order directing the respondent police officials not to harass the petitioner pending disposal of his plea. And lastly, the Madras High Court has granted bail to 8 men who were allegedly office bearers and members of the Popular Front of India, that is PFI, and were charged under UAPA for conspiring to commit terrorist acts in various parts of India. According to the complaint, the appellants had hatched a conspiracy to unleash terrorist attacks against perceived anti Islamic forces of other religions with an intention to threaten unity, integrity, security, and sovereignty of India and with an intention to strike terror. The appellants argued that the special court had rejected the bail application by merely saying that there was a prima facie case without any definite accusation against any of the accused persons or any material documents or evidence. It was further contended that the appellants were arrested merely for being members of an organization that was neither banned nor declared as an unlawful association at the time of the arrest. Pointing to the physical training activities carried out by PFI, the additional Solicitor General argued that commission of a terrorist attack or any act preparatory to the commission would attract UAPA. The court, however, observed that in order to bring an act within the meaning of preparatory, it should be proximate to the act which was intended to be committed. In the present case, though it was alleged that the organization was training people to throw bottles filled with water, when no petrol bombs were recovered, there was no proximity with the preparation and the alleged attack. The bench of Justice S.S. Sundar and Justice Sundar Mohan opined that the documents collected by the prosecution did not link any of the appellants directly to the offences alleged, and hence the special court had erred in denying them bail. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.